Hello and good day to everyone. This is Attorney Angel. Before we proceed with part 2 of this lecture on the rules of construction for specific laws or statutes, may I invite everyone to pause for a few seconds to say our own prayer with special intention of ending COVID-19 and also for our protection, for our safety, and for our good health. Amen. All right then. We will now proceed with part 2 of this lecture on the rules of construction for specific laws or statutes. Last week, we were able to discuss about the rules of construction for tax statutes, penal statutes, and social legislation. For part 2, we will be discussing about the rules of construction for the rules of courts, for local statutes, for adoption statutes, and last but not the least, constitutional construction. So let us proceed. Let us start with the rules of court. The rules of court is part of procedural law or remedial law or adjective law. If you remember, in the early parts of our classes, we discussed about the different kinds of laws, and we touched on substantive law and procedural law, or otherwise known as adjective law. So we said that substantive law are those that tell us what our rights and duties are, while remedial, procedural, or adjective law tell us how to enforce our rights. They provide remedies, procedures on how to redress our grievances. As to the rule of construction with respect to the rules of court, or remedial law, procedural law, or adjective law, they shall be liberally construed in order to promote the objective of securing a just, speedy, and inexpensive disposition of every action and proceedings. This rule has been used by the Supreme Court not only in respect of the construction of the provisions of the rules of court, but also in applying clear provisions of the rules of court with leniency, or in other words, to excuse technical compliance with procedural requirements of the rules of court. For example, in the case of OCA versus Garo, OCA stands for Office of the Court Administrator. The issue before the court here is whether or not the period for filing an appeal has lapsed. So this is a technical rule on the filing of an appeal. Period of filing an appeal. Here the Supreme Court said that rules prescribing the time within which certain acts must be done as certain proceedings taken are absolutely indispensable to the prevention of needless delays and the orderly and speedy discharge of judicial business. Strict compliance with such rules is mandatory and imperative. Nevertheless, the procedural rules were conceived to aid the attainment of justice. Okay, that is a very important phrase, attainment of justice. Or, as I recall, in one of my legal aid cases, when I attended the hearing in Manila, the regional trial court, forgot the branch number. This is the court presided by Judge Bunye Medina. I was supposed to proceed with pre-trial after the arraignment of my client. My client was the accused. But at that point, I was not able to confer yet with my client. So I pleaded before Judge Medina to allow me to proceed with the pre-trial at the next setting or the next hearing. Okay. As you know, under the continuous trial rule, the arraignment and the pre-trial are already in one setting or one hearing. But because I did not want to prejudice my client, because I have not conferred with my client, so I asked the judge if I can proceed with the pre-trial at the next setting or the next hearing. Okay, technically I could have not. I technically the judge would have not allowed me, but the judge, very compassionate and level-headed, Judge Medina, said that in the interest of justice, and if there is no opposition on the part of the prosecutor, then I can proceed with the pre-trial at the next hearing. Going back, so pursuant to this, under Rule 1, Section 6 of the 1997 Rules of Procedure, it is stated that these rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. Okay. Also, in another case, which I was not able to provide in this slide, in the case of Gold Loop Properties versus Court of Appeals, the court also held that where a rigid application of the rule will result in a manifest failure of miscarriage of justice, then the rule may be relaxed, especially if a party successfully shows that the alleged defect in the questioned final and executory judgment is not apparent on its face or from the recitals contained therein. Technicalities may thus be disregarded in order to resolve the case. After all, no party can even claim a vested right in technicalities. Litigation should, as much as possible, be decided on the merits and not on technicalities. But do not mistake that the court is not strict when it comes to the rules. Okay? So, in another case, a case of Goke versus CA, the court held that technical rules of procedure are not to be ignored. Thus, the Supreme Court stated that to merit liberality, the one seeking such treatment must show reasonable cause, justifying its non-compliance with the rules, and must establish that the outright dismissal of the petition would defeat the administration of substantial justice. Procedural rules must at all times be followed, save for instances when a litigant must be rescued from an injustice far graver than the degree of his carelessness in not complying with the prescribed procedure. Okay, this reminds me, if you were able to follow Attorney Tranquilo Salvador, he conducted a lecture about the rules on civil procedure and the new rules on evidence. Okay, I was able to listen to his webinar with respect to the rules on civil procedure. Okay, so under the new rules of civil procedure, the court is strict with respect to extension, okay, filing, and the extension of time for filing certain pleadings. So I was able to catch him say that under the new rules of civil procedure, the parties are entitled only to one extension of 30 days, and that the court already provided certain periods of time for filing certain kinds of pleadings. Like, for example, you're given 15 days to file your reply, 20 days for filing of an answer to counterclaims, 15 days for filing of supplemental complaint, and 30 days for amendment. But that amendment must be amendment as a matter of right. Okay. Now we move on to adoption statutes. These are laws on adoption or adoption statutes or adoption laws. Okay. Why is it important? Adoption laws are important because it does not merely establish paternity and filiation, but it raises the level of a child from illegitimate to a legitimate status. So the rule when it comes to adoption laws or laws on adoption statutes, is that they should be liberally construed in favor of the child to be adopted or the adoptee in order to promote the noble objectives of the law. And as we said, the noble objectives of the law to establish paternity, filiation, and endow a child with legitimate status. But if you put it in simple terms, it is simply the best interest of the child. For example, in the case of the adoption of Stephanie Astorga Garcia, here, in this case, the Supreme Court allowed the illegitimate child who was adopted by her natural father to use her natural mother's surname as middle name. But there is no law allowing that. So here in this case, the Supreme Court allowed that. And it stated that the policy that adoption statutes, being humane and salutary in nature, are to be liberally construed on account of the beneficent purposes of adoption, and that the interest and welfare of the adopted child should be primary and paramount consideration, and every reasonable intendment should be sustained to promote and fulfill the noble and compassionate objectives of adoption statutes. Here. Now we move on to the local statutes issued by the local government and also pertaining to local autonomy. So when we say local statutes, these are statutes, the operation of which is confined within certain territorial limits and applies to political subdivisions of the state or to property or persons of a limited portion of the state. You all know that political subdivisions are composed of the local government units in the Philippines, from the provinces, cities, municipalities, down to the barangays. And now we see them in action. They are very, very active now, especially in these times of crisis, this time of the pandemic. They are on the front line. So, legal basis. Under the Constitution, we have two relevant articles, two relevant sections. Article 10, Section 2, and Article 2, Section 25 of the 1987 Constitution. Okay, so let's go first to Article 10, Section 2 of the 1987 Constitution. Here it is provided that territorial and political subdivisions of the Philippines shall enjoy local autonomy. Okay. The territorial and political subdivisions are comprised of provinces, cities, municipalities, and barangays. I have mentioned earlier. The 1987 Constitution, and the other in Article 2, Section 25, guarantees the autonomy of these local government units. Okay. Another legal basis, Section 5 of RA 7160, otherwise known as the Local Government Code. There are rules of interpretation stated in Section 5. Okay. First is that any provision on the power of a local government unit, sorry for the typo error, shall be liberally interpreted in its favor, and in case of doubt, any question thereon shall be resolved in favor of devolution of powers and of the LGU. When you go to the law on public corporations, you will often hear the word devolution. And aside from that, its twin term or word, decentralization. Next, in case of doubt, any tax ordinance or revenue measure shall be construed strictly against the LGU enacting it and liberally in favor of the taxpayer. Any tax exemption, incentive, or relief granted by any LGU shall be construed strictly against the person claiming. So we already took this off when we discussed about the rules of construction for tax statutes. Okay, and third, The general welfare provisions of the local government code shall be liberally interpreted to give more powers to the LGUs in accelerating economic development and upgrading the quality of life of the people in the community. In statutory construction, where a law is capable of two interpretations, one in favor of the centralized power of the national government and the other beneficial to local autonomy, the rule of construction is that the scales must tilt in favor of the latter, meaning the scales must tilt in favor of local autonomy. So in the case of San Juan versus the CSC, or the Civil Service Commission, this was about the appointment of a budget officer in an LGU, in this case, the LGU San Juan. Okay. The particular provision of law in contention is Section 1 of EO 112. Okay. Let me read to you that particular section of the EO 112. States that all budget officers of provinces, cities, municipalities shall be appointed henceforth by the Minister of Budget and Management upon recommendation of the local chief executive concerned. Local chief executive referring to the mayor. Subject to civil service law, rules, and regulations. And they shall be placed under the administrative control and technical supervision of the Ministry of Budget and Management. Okay. So here the Supreme Court held that the phrase upon recommendation of the local chief executive concerned is part and parcel of the appointment process and is a mandatory requirement. Okay? So the Budget and Management Ministry cannot appoint a budget officer who is not recommended by the local chief executive or the mayor. So this must be satisfied, this requirement must be satisfied even if the first person recommended by the mayor fell short of the requirement. So it will go through that process, but it should be recommended by the local chief executive or the mayor. Okay. We've now come to the last part of part 2, which is on the Constitution, or specifically constitutional construction. Okay. For Constitution, for this discussion, let us look at two perspectives. The first perspective is the Constitution with respect to other statutes or laws. And the other perspective is with respect to the constitutional provisions themselves. So, to proceed, we all know that the Constitution is the fundamental law of the land. It's the organic law of the land, okay? And we learned in our previous classes with respect to the hierarchy of laws, the one that occupies the highest position in that hierarchy of laws is the Constitution. So that with respect to statutes, the presumption is always in favor of the constitutionality of a statute, because all laws should be in accord with the Constitution. So otherwise, if the statute is held to be unconstitutional, what is the effect? The effect is that there is no law. It confers no rights. It imposes no duties, and it affords no protection, and it creates no office. There is also another view that even if the statute is held to be unconstitutional, it is nevertheless considered a legislative act because it passed through the process of legislation. Okay? But these are commonly spoken of as void. So with the constitutional provisions itself, the Supreme Court adopted 3 basic principles of statutory construction in their interpretation of the Constitution, and you are familiar with them, especially when we discuss about the Latin maxims, okay? Verba legis, or the plain meaning rule. Ratio legis, or the ratio legis est anima, the spirit of the law, and the interpretation of the Constitution as a whole, or ut magis valeat quam feriat, or ut magis valeat quam feriat. So just a review, you know that verba legis is the rule that whenever possible, the words in the Constitution must be given their ordinary meaning, except where technical terms are employed. And then ratio legis est anima. Whenever there is ambiguity, the words of the Constitution should be interpreted in accordance with the intent of its framers. Okay. So you remember the case of Nitafan versus CIR? It was held in that case that the ascertainment of that intent is but in keeping with the fundamental principle of constitutional construction, that the intent of the framers of the organic law referring to the Constitution and of the people adopting it should be given effect. Okay. And as we said, ut magis valeat quam feriat. The Constitution is to be interpreted as a whole. To further explain, you know the landmark case of Civil Liberties Union versus Executive Secretary. So this case told us that no one provision of the Constitution is to be separated from all the others. The interpretation as a whole is provided by ut magis valeat quam feriat. Okay, so in this case, it was held that it is a well-established rule in constitutional construction that no one provision of the Constitution is to be separated from all the others to be considered a law, but that all the provisions bearing upon a particular subject are brought into to be so interpreted as to effectuate the great purposes of the instrument. Sections bearing on a particular subject should be considered and interpreted together as to effectuate the whole purpose of the Constitution, and one section is not to be allowed to defeat another, if by any reasonable construction the two can be made to stand together. So simply put, the court must harmonize all these provisions if practicable, and it must lean in favor of a construction which will render every word operative, rather than one which will make the words idle and nugatory. So here we have other considerations. Contemporaneous construction and aids that are external to the text may be resorted to when the text is capable of multiple or viable meanings. Okay. Speaking about contemporaneous construction, contemporaneous construction is connected to contemporaneous circumstances, contemporaneous and practical construction as well. Okay. So when you say contemporaneous circumstances, these are part of extrinsic aids, those which are external to the letter of the law. Okay. So when you say contemporaneous circumstances, these are conditions existing at the time that the law was enacted. Like for example, the history of the times or the conditions of the times when the law was enacted, or the previous state of the law, or evil sought to be remedied or corrected by the law, and the customs or usages of the people back then. So the one interpreting the law should place himself in that position and circumstances. So to understand the words used in question and to be able to feel the atmosphere back then and the reasons why the law was enacted. So contemporaneous and practical construction is connected to that, because these are the contemporaneous and practical construction tell us that those who lived at or near the time when the law was passed were more acquainted of the conditions and the reasons why the law was why that particular law was enacted. So their understanding and application of the law, especially if the same has been continued and agreed upon or acquiesced by the judicial tribunals and the legal profession, deserve to be considered by the courts. Okay. With respect to the question of whether or not the provisions of the Constitution are self-executing or non-self-executing, or whether not the provision of the Constitution is self-executory, non-self-executory. Okay. The general rule is that the provisions of the Constitution are intended to be self-executing. Okay. I know you're also familiar with this case, Oposa versus Factoran, landmark case, wherein the provisions in contention are sections 15 and 16 of Article 2 of the 1987 Constitution. Okay, just to refresh your memory, let me read to you all the particular sections. Okay. Section 15, Article 2, 1987 Constitution. The state shall protect and promote the right to health of the people and instill health consciousness among them. Section 16, the state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. Okay. So it was held by the court that the right of the people to a balanced and healthful ecology under Article 2, Sections 15 and 16 carry the correlative duty to refrain from impairing the environment, and this includes the judicious management and conservation of the country's forests. So while the court did not expressly state that the said provisions are self-executing, by its holding, the implication is that the aforesaid provisions, sections 15 and 16 of Articles of the 1987 Constitution, can be valid sources of rights which may be enforced by the courts. So, Justice Feliciano concurred with the majority opinion. And he noted that as a matter of logic, by finding petitioner's cause of action as anchored on a legal right comprised in the constitutional statements, the court in effect said that Article 2, Sections 15 and 16 are self-executing and are judicially enforceable even in their present form. So the doctrine of self-executing provisions of the Constitution was also expressly laid down in the case of Manila Prince Hotel Corporation versus GSIS. Okay. I know you're familiar with this case because I assigned this case to you. Okay. This was about the Manila Hotel being put up for sale and opened by GSIS to bidders. 30% to 50% of the shares in Manila Hotel were up for bid. So in this case, you remember that Manila Prince Hotel Corporation, or MPHC, was one of the bidders, and the other bidder was Renang Berhad, which is a Malaysian corporation, in which GSIS favored Renang Berhad because it had a higher bid than MPHC. But MPHC wrote to GSIS and matched the bid of Renang Berhad. Okay. But GSIS refused to accept the match bid of MPHC. So MPHC filed a petition before the Supreme Court for prohibition in mandamus. Okay. So the article in contention here, particular article of the 1987 Constitution is Article 12, Section 10. Okay. If you remember, this article is with respect to the Filipino First policy. Okay. So, the issue was whether or not Article 12, Section 10 of the 1987 Constitution is self-executing. If you remember, GSI has argued that the second paragraph of Article 12 of Section 10 is merely a statement of the principle and policy, since it is not self-executing and requires legislation. But the Supreme Court ruled otherwise. The Supreme Court ruled that unless it is expressly provided that a legislative act is necessary to enforce a constitutional mandate, the presumption is that all provisions of the Constitution are self-executing. If the constitutional provisions are treated as requiring legislation instead of self-executing, the legislature would have the power to ignore and practically nullify the mandate of the fundamental law. So the prevailing view is that in case of doubt, the Constitution should be considered self-executing rather than non-self-executing, unless the contrary is intended and the provision of the Constitution should be considered self-executing. So if you notice in Oposa versus Factoran, it was merely implied, but in MPHC, which is a later case than Oposa versus Factoran, it was expressly stated in the decision of the Supreme Court that constitutional provisions are self-executing rather than non-self-executing, unless the contrary is intended. So that's it for part 2 of this lecture on the rules of construction for specific laws or statutes and constitutional construction. So if you want to read more about these topics, my sources are, of course, as I told you in our class, our reference books are Statutory Construction Concepts and Cases by Attorney June Pelares and Statutory Construction by Attorney Rolando Suarez. Thank you very much. I hope you were able to take down notes, and I hope you learned something from our lecture. So always remember to glorify God with a grateful heart. Stay safe. Be happy. Thank you very much for listening.